Emergency abortions can be performed in the state of Idaho regardless of the state's abortion ban, so says the Supreme Court. But this is not over. The justices basically kicked the can down the road by saying, we screwed up in even taking this case in the first place. And yes, in case you're wondering, this is the same case that was accidentally released by the Supreme Court yesterday. Now, by and large, when you look at yesterday's document release that showed up on the website and today's real opinion, they look very similar. So let's talk about what that official opinion says, or more like what it doesn't say. Today's ruling from the justices was really just a temporary win for the Biden administration and abortion rights advocates. Today's ruling simply says emergency abortions in the state of Idaho can continue while their legal cases continue to play out in the lower courts. The Supreme Court did not address the main issue, which was, when it comes to abortion, if state law conflicts with federal law, which one prevails? At least for today, the justices said the federal law will win. And that federal law is the Emergency Medical Treatment and Labor Act, or EMTALA. That law has been around for 40 years and says hospitals receiving federal funds, which is like all of them, must stabilize or transfer patients needing emergency care and must provide care regardless of patients' ability to pay, mental illness, or other complications. After the Supreme Court overturned Roe versus Wade, the Justice Department issued guidance to all hospitals nationwide saying abortions are considered emergency care and must be performed at hospitals across the country, regardless of the state abortion laws. The problem with that is the law in the state of Idaho makes it a felony to perform an abortion. There are exceptions to that law, but only if the life of the pregnant patient is in danger or if there was a provable, with a police report, case of rape or incest. The conflict is, under EMTALA, emergency care is not only required if the life of the pregnant patient is at risk. It is also required if the health of the pregnant patient is at risk. And that is a significant difference. Now, in today's ruling, 6 of the justices, Barrett, Kavanaugh, Kagan, Sotomayor, Jackson, and the Chief Justice all said, we screwed up. We stepped into this case way too early, and we should have waited until the cases officially made their way through the lower courts. So until these cases come back to us, which obviously they will, these EMTALA emergency abortions can continue in the state of Idaho. The problem is, Idaho isn't the only state where this very same conflict exists. There are more than a dozen other states with this exact same issue. And today's decision leaves everyone in limbo. While that's problematic, what's actually more interesting about today's decision is the concurring opinion from Justice Jackson and the dissent from Justice Alito, joined by Thomas and Gorsuch. Justice Jackson is pissed the court decided to kick the can down the road. She writes, so as of today, the court has not adopted Idaho's far-fetched theories, but it has not rejected them either. Instead, the court puts off the decision. But how long must pregnant patients wait for an answer? Justice Alito agrees that the Supreme Court should have ruled on this case, but he thinks Idaho should have won. He has a problem with the Justice Department's interpretation of EMTALA, saying just because the law says hospitals are required to stabilize and transfer patients, that doesn't give them the green light for abortion. He says the government's preemption theory is plainly unsound. Even if there were some ambiguity in the statutory text, we would be obligated to resolve that ambiguity in favor of the state. So if you want to read this ruling for yourself, I will email it out to you tonight in my News Girl News Roundup email. Make sure you sign yourself up.